Hello, welcome back to my channel. I look like a drowned rat. It is pouring with rain today. We're in for a very wet spring, which is really interesting. It only rained when I finished work and I was leaving work. It rained as I was going to work. It rained and I had my hands full when I'm going to work. And then it rained as I was trying to get everything loaded up. But look, we've got some stuff that's going on in the Crikey and Murdoch. So this is the file for Lachlan Murdoch versus private media. I'm just going to call him Crikey because, but the official name. So look at all of these documents. So we read we've read the complaint and the response. So we read the claim, the defense, and the reply. Then there's an outline of submissions. There's been some. Now we've got 2 interlocutory applications that's been done. So outline of submissions. So here we've got. So Murdoch has filed an application. Then private media's filed application with submissions and affidavit. Some more submissions, outline submissions. There's been a couple of administrative listings. So there was one today that said by 2 p.m. the respondents filed and said their submissions and then by 4 p.m. on the applicant filed and said submissions. The interlocutory application will be listed for hearing on 10/15, the 10th, 2022. Okay, so that's that one, and then there was this one which was earlier. So it's just all administrative stuff. Oh, why has that one done that for me? Oops. Why is that doing that? Okay. It's not. Oh, there we go. I don't know. All right. Yeah, it's just not. Anyway. I don't know why that's not letting me have the orders. Oh, it says it failed to load. Okay, I had it up before. That's the irony of it. All right. Well, here we go. So by the 4 p.m., serve the particulars of defence. So they had to serve the defence and then any proposed amendments by the 30th. The 4th, they had to serve submissions. So we've had all of that. And so this is the outline. So the interlocutory hearing. Yep. On or before 4 p.m. the 4th of November, each party must serve evidence of witnesses and affidavits in relation to the issues. On or before 4 p.m. on the 18th of November, each party must serve outlines of evidence. Yep. On or before the 18th, each party gives standard discovery. Then you've got the 23rd of November, exchange proposed interrogatories. 25th of November, notify of any objections. 21st December, file answers. The matters to be listed for case management hearing on the 30th of November. And it's listed for hearing with an estimate of 9 days on the 27th of March, 2023. Okay, so that's the outline of discovery and all of that sort of stuff. So we're there. So now we come to here, and we've got the interlocutory applications. Now I'm going to open these up. I've got to open all of these up again because what we've got is we're going to have lots of we object to this and we object to that. So this is an interlocutory application. Now this is for Murdoch. So matters paragraph. So we're going to pull up the defence as well. Paragraphs 1 to 16 of defence filed in the 20 September defence to be confined to matters within belief and state of mind of the respondents as alleged in paragraphs 17 to 22 of the defence and not be questions of objective fact. So let's look at the defence. All right, so here's the defence. So 1 to 16, not objective facts is belief. So they're saying it needs to be belief. And then 17 to 22, and not be questions of fact. Okay. So paragraphs 1 to 16 need to be confined to matters within the belief or state of mind of respondents as alleged in paragraphs 17 to 22 of the defence and not be questions of fact or objective fact. Paragraphs 1 to 22 of the defence be confined to matters going to the defence as pleaded in paragraphs 42 and 43 of the defence. Okay, so we go to 43, 42 and 43. 42, reasonable belief. And which is the respondents in reliance say that the matter was published on the occasion of qualified privilege. Okay, all right. Oops, is that the... Then we've got the respondents in accordance with Rule 6 have replead paragraph 30 of the defence to answer each allegation of fact in paragraph 8 of the statement of claim. So respondents in accordance replead paragraph 30 to answer each allegation of fact in paragraph 8 of the... So they've got to read... So they want them to replead paragraph 30, which says the respondents deny the allegation in paragraph 8 of the statement of claim. Paragraph 8. So they want it played properly. This is how it's done. Paragraph 8. Where are we? 6, 9, 8. Here we go. My serious harm. So they want each of these. So to extent they want each of those pledged individually. So the articles. So they want paragraph 30 to answer each of the allegations of fact in paragraph 8. So they want paragraph 30 to be repleaded. Paragraph 37 of the defence to be struck out. Paragraph 30 says, furthermore, which is denied, Lachlan Murdoch is found to be entitled to any damages as a result of the publication of any of the matters complained of. The respondents will rely on mitigation of damages upon the following: the matters alleged in paragraph 1 to 22, the facts, matters, circumstances, the bad reputation of Lachlan Murdoch amongst the Australian people for his role as CEO of Fox News, a conservative media channel providing biased reporting in favour of conservative political positions, and News International, an organisation that engaged in systematic unethical practices in investigative reporting. The circumstances is which it is proved the matters complained of were published, such further matters be identified in the following discovery. So they want that struck out, okay? They want that gone. All right. That's their one. All right. So then they want respondents to file amended defence limited to reflecting orders 1 to 4 above. So they want an amended defence filed. The respondents pay the applicant's costs for this application, including any costs. So this is what they're arguing on Monday. So they want these orders. So this is what Murdoch wants. So in response, so now private media, or Crikey, have said, well, we want paragraph 5.5 of the reply struck out. So 5.5, so says that in publishing the article, private media Keen and Freight were instead actuated by malice, in that they predominantly acted with the improper purpose or purposes of harming Murdoch and or seeking to attract unwarranted attention to article by using Murdoch's name as evidenced by matters set forth in paragraph 7 a lot below. So they've said, we want that struck out. We want an amended reply to reflect that. And we want the applicant pay respondents' costs in this application, including any costs. So they've both asked the court to order the other side to amend their documents. So this looks like this is going to be a real bun fight. It's going to be very, very interesting. This is how it's done. Yeah. So at 10:15 on Monday, I don't think that it will be able to be viewed, but if it is, I'll see what I can do. It doesn't. This argument is going to be heard. Either they're both going to have to resubmit documents with changes, or the judge is not going to. Yeah, it'll be interesting to see. So this is far from over. I don't know really what's going to happen. I cannot predict this one. As I said, they've just gone, we want this struck out, we want this struck out, we want this reworded, We want you to force them to do that. I'm interested to hear what you have to say about this. Let me know in the comments below. Make sure you hit like and ring my bell. Ring my bell. Ring my bell. You can also become a member of the channel. You can support the channel. You can hit thanks and send a super thanks. I've got PayPal. I've got Buy Me Coffee. I've got all sorts of ways that the channel can be supported. And I'll catch you again next time. Bye for now.